Network's website series. For those of you that may not be familiar with SBRN, we're a network of professionals who provide services to the business community. We're an affiliate of the Florida Small Business Development Center Network. My name is Nancy Boyle. I'm the director of the program, and our members are professionals, those key professionals that every business owner needs. We have accountants, business attorneys, commercial lenders, commercial insurance agents, business consultants, a variety of government and nonprofit organizations, and some select other corporations such as payroll and specialty advertising, etc. You can visit our website at sbrn.org. And a couple of quick housekeeping things before we get started. If you have questions, please type them in the question area. With a smaller group, we may be able to answer them as they come up, but if not, we'll address them at the end. We are recording this session, so you will, at the end of this, get a link to where you can go back and review the materials again. You'll also, at the end of this, get a link to an evaluation form. It's a very quick little survey we do for all of our webinars. So we're asking if you would please, at the end of this, do that short survey. So without further ado, let me introduce our speaker, Mark Addington. Mark is the owner of Addington Law, and he focuses his practice primarily on employment law. He does litigation as well as prevention methods, which is important so that hopefully you don't have to go to litigation. Mark received his law degree from the University of Florida Law School. He is also, not only was he a student and a lawyer, but he's also an adjunct professor here at UNF. He's taught at Phoenix and several other educational institutions in the area. He is a frequent speaker and lecturer at statewide conferences and seminars. He has presented at HR Florida and the Florida Restaurant and Lodging Show. He's talked about various different topics such as workplace technology issues, military leave, disciplinary documentation, Family Medical Leave Act, and the beat goes on. So without further ado, let's welcome Mark Addington of Addington Law.
Thank you for the introduction. And the beat goes on. Now I'll get to the important stuff beyond my bio. These are weird times right now with the pandemic. Small businesses and medium businesses are the focus of my law practice. I've been proud to be associated with SBRN now since 2009. So I guess we're coming up on 12 years or so. And in that time, have been blessed to work with lots of various professionals and their clients to try to help mitigate damage and or stay out of litigation. And then, of course, if we're in litigation, represent and advocate their positions. The purpose of today is to talk about the wage and hour laws. The wage and hour laws are, to a certain extent, in some flux. And for small businesses being able to plan, especially during these uncertain times, I think it's really critical that you start thinking about compliance-related things in regards to how people are paid, as well as how you're going to continue to survive under some strenuous economic times. And so I'm going to go through and kind of start with an agenda and talk a little bit about what I want to talk about in this presentation. That doesn't necessarily mean that if you have questions a little outside the scope, I wouldn't do what I can to entertain them, but probably would focus on what's on the agenda initially. And if you have a question outside of the scope, please feel free to submit it. I'll address that afterwards. If you have one inside the scope of what we're talking about, I'm happy to do that as we go. And we'll just work together and we'll hopefully make this as valuable an experience for you as possible. The first aspect that I want to talk about is minimum wage law. And there's a Florida minimum wage law as well as a federal minimum wage law. There's a lot of talk about raising the minimum wage. I think the average business owner is aware of most of this, but may not be aware of exactly what has happened to date and how it affects them. And a lot of it depends upon your industry and your wages that you're currently paying, et cetera, et cetera. But we'll talk about that first. After that, I'm going to talk a lot about the regulatory agencies. These are the agencies that the president controls that are ultimately enforcing the laws that are passed by Congress. And so there's a lot of changes because we just changed administrations. So what changes do I see happening immediately? What kind of changes are coming up that really are going to create some compliance problems? Things of that nature I want to talk a little bit about. And then the third part is some changes with regards to benefits. I'm not a benefits lawyer per se, in that I don't deal with pension plans and things like that, but I do deal with litigation that has to do with the way benefits work. And there are some novel things that have happened because of the pandemic that I think make it appropriate for this discussion. So those are the three main areas I'm going to be dealing with. If you have a question outside of those, please ask it, but just recognize I'll probably move those types of questions to the end and try to focus on making sure I cover these areas and these topics really, really well for you. So let's talk a little bit about the minimum wage. And I have a poll to start with on the minimum wage. So I'm going to start with that. And I have Allie helping me in the background, and hopefully she is putting up for you a poll. I do see that the poll is now open. And so the poll question is, what is the current minimum wage for Florida employers? And you have A, B, C, D, or E to select from. So Allie, give me an indication when everyone's done, and go ahead and post those results if you will.
Okay. Are you able to see that, Mark? We've got 100% that said it's 856.
Okay, I'm not able to see it, but I'm thrilled that everyone got it right. But what are these numbers I chose for this poll question? Well, the $1.60 was what it was when I graduated high school. And $7.25 is the current minimum wage on the federal level. But the question that I gave you was for Florida employers. And as is clear what you know, the minimum wage for Florida employers is $8.56, and last year it was $8.46. And the $5.54 figure, actually, you'd probably get partial credit for, because that's the current minimum wage for tipped employees. So in looking at and thinking about the federal and the Florida minimum wage, all of my audience is aware that Florida is paying higher than the current federal minimum wage of $7.25. Why is that important? When we think about minimum wage, a lot of businesses may have very few minimum wage employees. I will tell you that there's some things that you have to remember. You have to pay the highest applicable minimum wage. In some places, not in Florida, but for instance in California, in certain municipalities, they have a minimum wage higher than the state minimum wage. So whatever is the applicable minimum wage, you have to pay the highest of those, and make sure you understand how the minimum wage is calculated in that jurisdiction. It's also important that if you take money out of their checks, that you have some sort of documentation or agreement. And when we think about deductions, that can get confusing. So if you're not sure, get with an HR professional or a lawyer and answer any questions about deductions, because deductions is an area that the Department of Labor frequently challenges if employees aren't happy with it. If you can produce an agreement, it becomes very easy for you to defend yourself. With regards to tipped employees, make sure that you're only taking credit on those that are eligible. And I don't go too much into the details on tipped employees here, other than to highlight both that you need to make sure you're paying the right people, less than minimum wage, that tipped rate, and they be the correct people. And also, if you have a tip pulling practice, be very careful, because while it's currently very, very prominent in many hospitality industry, restaurants, hotels, things of that nature, who is eligible to take tips from a tip pool has differed between administrations and agencies that are enforcing it. So again, this is an area I don't go too far down, but we'll be happy to explore questions if you have with regards to those. When we think about the minimum wage for the federal level, this is kind of what it looks like. It goes up every once in a while, and it's not uncommon to see it continue to grow. However, the last time it grew was 12 years ago in 2009. And so there's a really very strong push for minimum wage to continue to grow. Florida, as you know, from our poll, is different because it is higher than the federal minimum wage. So why is this important to you at all? Florida is higher. Well, first of all, Florida passed a constitutional provision that raised minimum wage to $15 an hour. And so in the raising $15 an hour, it's going to continue to go up, but there's similar legislation right now in Congress. So what happens if both of those laws pass? What does that look like with regards to businesses' obligations? Right now, what is being proposed is the Raise the Wage Act, and this is a federal piece of legislation that basically says right now it's $7.25, but we want to raise it to $9.50, and then $11, and then $12.50, $14, and then $15, with the goal of getting minimum wage all across the country to over $15 an hour by the year 2025. I want to point out a couple of things. First of all, that's over double the current level. So essentially, if you are running a profit loss, a P&L statement on a business, and you're in a hospitality industry and you're paying predominant minimum wage, for instance, or if you're whatever industry and you have a significant number of your workforce that is at or near minimum wage, this is going to make a major impact in your operational costs, clearly. And you're going to have to figure out how to deal with that. And that's across the country because this is a federal law. The state law, as we said, is different. We have about 25 states that are going to increase their minimum wage. Florida is going to increase in September, and I'll show you that in a moment. But Florida is a little different than many states because we actually created our minimum wage law initially through constitutional ballots. And so it's a really interesting aspect of our law that minimum wage is a constitutional issue. And in most jurisdictions, it's a legislative issue. Of course, legislation and administrative regulatory rules are going to be promulgated to enforce the constitutional measure. And so as those types of rules come up, interpretations and potential for litigation are certainly there. So Florida is definitely increasing because it enacted in this last election cycle a measure to increase to $15 an hour just in the state side. So Florida employers, you are going to 100% be paying $15 an hour eventually because the state law is going to mandate it. Now, on the federal level, I told you about what the federal rule looked like, but let's look at the state rule in terms of that amendment and give you an idea so that you can try to plan what this operational expense would be to small business. Right now, the minimum wage for today, as you stated earlier, is $8.56 an hour, or a 302 tax credit or tip credit, which would be $5.54 for tipped employees. Starting September, that would raise to $10 an hour. So we would have immediately a $1.50 raise for all minimum wage employees. Now, I will tell you that prior to being an attorney for 17 years, I ran and worked in the restaurant industry. And I'll tell you a reality of the restaurant industry is that a lot of employees are low wage and reliant on tips. And there's lots of employees that sort of view how they're doing with their job by how far above minimum wage they are. So for instance, if I were making $8.56 an hour and minimum raise, and I was a minimum wage employee, I'd be really excited about that bump to 10. But what if I'm making $9.50 an hour? I'm only going to get a 50-cent raise, and everyone else that's lower than me and hasn't been there long is going to get a raise of $1.50. So one of the challenges for small businesses is not just the raise and the finances of funding it, but frequently employee-related issues. I was making $1.50 more than my coworker. How come now we're making the same? And am I valued the same? I've been here longer and I've been doing more things. So from a human resource perspective, raising the minimum wage this significantly is going to create a lot of issues in the workplace beyond financial. That's the reality of many small businesses that are low wage industries. And so that's something to think about as you're doing your planning, recognizing there's going to be a human side as much as an economic side to addressing the problems that minimum wage will cause small businesses. In addition, looking at Florida's minimum wage, it's going to go up $1 a year until 2026, and then it'll be at $15 an hour. Now, both the new proposed federal rule and this particular constitutional amendment, after it reaches $15 an hour, is going to tie continued raises to the rate of inflation. Okay, so it will not be as drastic after 2026, but between now and 2026, for small businesses that are trying to survive in a pandemic, this, in my view, personally, is going to be a major challenge for small businesses. And how they address that is going to require a lot of thought and planning, not just from an economic perspective, but from a employee relationship perspective. So those are things to think about proactively and start thinking of and developing plans for. If we were to look at both the federal rule that is proposed and the new Florida amendment that is the law, how would that look like? What would that look like for employers? Well, right now, minimum wage is $7.25 on the federal level, therefore not applicable to us because in Florida we use the higher rate of $8.56. Next year, these rules will mean you'll still be paying Florida's rate because it jumps higher the first year to $10 an hour. In 2022, both of them are at $11. And then after that, you will find that the federal rule is always going to be higher. And it's also going to get to $15 an hour sooner than the state rule. One good thing, if you're looking for a good thing to pull out of this, is there is no uncertainty if the federal rule passes as to what minimum wage is going to be until 2025, because you will take the higher number, $8.56, $10, $11, $12.50, 14 and 15, and that is what minimum wage will be for planning purposes through the year 2025. And after that, it's a guess because it's going to be tied to inflation, but should not be as drastic. So I wanted to overlay what the Florida rule is, because that's the law of the land for Florida employers, but only unless or until the federal rule would supersede it. And with the current legislation, that's a strong possibility. So that is kind of a layout of what minimum wage is going to look like. But we are going from $7.25 an hour for minimum wage to, in 5 years, if the federal rule passes, and 6 if it remains in Florida, that being doubled. And so there's going to be a lot of hard discussions that small employers are going to need to do to keep up with the ever increasing labor costs. Again, the higher of these rates is what's applicable to us as employers. When we think about the impact of the Minimum Raise the Wage Act, and in Florida, the fact that we've already passed the constitutional measure. There are some statistics that the Congressional Budget Office put out that basically say that 27 million Americans will make more money. And of course, the tenor is raising lower wage workers out of poverty. And so that's one of the ways that they look at it, is the increase of wages. From a business perspective, where is that increase coming? Well, we're going to have to do some things to respond. It could be altering prices, could be changing productivity or job structures, it could be automation. It looks like right now, if you just believe the CBO, the Congressional Budget Office, 1.4 million jobs could be lost, and a lot of small businesses may go out of business. And many think that because of the pandemic, it may not be accurate. The number may be even much higher. So small businesses, I'm talking to these about proactively, encouraging you to start looking at both the economic and the relationship aspects of this issue and trying to develop a plan, because we're starting to see that in Florida, you're going to have to go to $15 an hour by 2025. And that may be even higher at, at certain points, because if the federal legislation passes, that number from 2022 to 2026 is actually much higher. Productivity is going to be really key for small businesses to survive. Ways to automate, ways to streamline, ways to control costs are significant. And of course, the alternative to that is raising prices. And what will the market bear when you have such a strained economy is a very difficult question for a lot of businesses to figure out. So it's definitely a challenging economic time. There is some discussion with this federal law that hasn't passed yet with the idea of locally or locality-based pay. And that makes a lot of sense. If the federal government wants to make a minimum wage that goes all the way to $15 an hour, well, the benefit to an employee in Jacksonville might be significantly different than the benefit to an employee in New York or Boston or in some other economy where the cost of living is much different. So there is a lot of discussion now between legislatures with regards to creating some sort of segregated locality-based program instead of the Raise the Wage Act. Ultimately, in my opinion, most legislators would probably say, why don't we just default to the states and let the states continue to create those laws and not pass the act? I don't know what will happen. That's all speculative. But in my particular view, I think it's difficult for the federal government to manage a simple rule, and when you make it complicated and create variables between jurisdictions or between areas because of economic reasons, I think it's going to be very cumbersome for them to enforce well. So for that reason, my prayer is that the Raise the Wage Act doesn't happen, but that still isn't going to help Florida employers much, because we have a state constitutional mandate to raise to $15 an hour, as we've discussed. So anyway, that's a little bit of what I wanted to talk about with regards to the minimum wage. Does anyone have any questions about that? Was that fairly clear in terms of where we are and where we're going with regards to minimum wage? If you have a question, don't hesitate to let me know. I'm going to go ahead and go right into the discussion of the various regulatory agencies. And a couple of things that kind of pertain mostly. We have a second poll question. So if Allie can help me to administer the poll question, this will be an interesting one for you to think about. Polls are now open. What tests are available to determine if a worker is an independent contractor? A is the IRS 20-part test. B is the economic realities test. C is a hybrid using various elements. And then either A or B or A, B, or C. And Allie, let me know when you've got all the answers and give me an idea what they look like, because I can't see the results on my side.
Okay. It looks like 50% say A and 50% said E.
Okay, that's good. That's not a bad outcome. E is the correct answer. And one of the challenges with this area of the law is that it's not bright line or clear. So employers, businesses that are working to make relationships with workers and decide how they're going to treat them have a number of varying answers that no one clear test. The IRS had a 20-part test that it's used for decades. And in about 2005 or so, 2005, it really just took those same elements and reorganized them into 3 areas. And I'll show you that in a minute. But the courts, while they looked at the IRS's test, the Department of Labor kind of created this economic realities test. And an economic reality test basically says, is it an economic reality that that worker is truly independent of the business? That's kind of the gist of the analysis. And it looks at a couple of aspects. One is, to what degree are they truly independent? But another aspect of it is, to what degree does the business control the worker? And so one thing that you want to think about with independent contractors is, are you contracting for a result, or are you managing the process to get the result? Because the more inclined you are to manage that process to the result, the more inclined a court or a Department of Labor or other administrative agency is going to say, you're not focusing on a result and contracting for a result, you're treating them like an employee and managing the process. And so that's a difficult analysis to do, because jobs are different, requirements in terms of reporting progress on jobs are different, whether or not in the degree training is provided with regards to jobs vary. And the economic realities test is one in which the court has said it is to be analyzed on a case-by-case basis. So there's lots of variables with regards to the idea of determining whether a worker is truly an independent contractor. So when we think about whether they're an independent contractor or employee, part of what the IRS says, if they have the right to control and direct only the result, okay, not what will be done or how it will be done, then we're going to call them an independent contractor. And they have 20 factors that they give no guidance as to how those factors are weighed. So in my view, and in most people that look at the law's view, this is to a high degree a subjective test. What constitutes more or less control in certain facts? And so it's difficult for businesses because there's not a bright line rule. There's lots of factors that are weighed in this analysis. Ultimately, the evidence of control or independence is what we're looking at. And as I said, in 2005, the IRS broke that down into 3 areas. Who exercises right to the behavioral control? Is it the worker able to control their own behavior until they get the result, or is the workplace imposing scheduling requirements, using certain types of equipment? Are we providing the equipment, et cetera, et cetera? Second aspect is financial control. How are expenses paid? Is there an invoice? Does the contractor have a separate entity set up that they are allegedly working through as a separate business? And you're not required to do that under a law. Individuals can be contractors, but again, that's evidence with regards to the business aspect of the worker and how they're handling that. And then with regards to the type of relationship, are there contracts? Are you providing them some types of benefits as a worker? Is the idea of the relationship continuous? And here's another one: is the work really key to the business? when I was working in the restaurant industry, we had a beautiful restaurant and we had these very expensive and ornate Persian rugs in the lobby area. And I would contract with a company to come by monthly and clean those rugs. The appearance of my restaurant was important and key, I think, to my business in many ways. But that function and that job is certainly different under the law than, say, the chef who's working to recipes and we're creating specific standards and he's controlling not only the work product but the process. So the idea of that relationship and what it looks like is part of the analysis as well. The determination of a independent contractor employee is very, very difficult. And the reason that I'm bringing this up and talking about the IRS test and then the economic reality test is because these are the two main tests that are out there, but courts have looked at all of these various factors, and there are many more. This is not a limited universe, the ones I put on the screen, but courts have made, because it's not a single rule bright line test, they've made decisions with regards to the facts and how they're going to weigh one factor versus another. So this is a difficult area for businesses to always get right, and that's just the reality of it. If you were part of the administration for President Obama, you actually told the workforce and the workplace that we're going to consider everyone an employee unless you prove strongly that they're not. And in 2009, one of the reasons that I started my law practice then was that he said, we are hiring hundreds of investigators and we are going to look at businesses that are claiming workers are independent contractors and make sure they are. And a big part of the reason for that sort of aggressive advocacies to classification of employees was because, candidly, as an independent contractor, that contractor pays their own taxes and there's not an employer portion involved. And so one way in which the government makes sure they get more taxes is if you have employees as opposed to independent contractors. And candidly, businesses versus independent contractors are more reliable in terms of getting their taxes in correctly. So statistically, there was ways in which they felt they would increase money coming from businesses to the government by virtue of challenging whether these classifications were done appropriately under the law in the Obama administration. This is one area that the Trump administration, when they came into power, looked at carefully, and they made a decision to create a independent contractor test, and that was being implemented near the end of the Trump administration's tenure as president and in charge of the administrative agencies. So that rule that was created was rescinded. However, and I'm saying this totally understanding that employees need to be classified properly, this really would have been a very good bright line rule. Ultimately, it would have created a new economic realities test that only looked at two key factors: the nature of the control and the opportunity for profit and loss. And then if both of those pointed in different directions, you had three guidepost factors that you could look at to make a decision. So rather than 20 rules, 20 different factors with no guidance as to what weighs more, and just saying the totality of the circumstance, under this new rule that will never come to pass because it's been rescinded, ultimately, we would have had a lot of guidance as to what's truly important. And if that's not dispositive, only three things we have to look at to do the analysis. So in my view, as somebody that litigates this would have been very, very good, both for independent contractors and for businesses, because it would have given some clarity to the issue. Now that it's been rescinded, what the Biden administration will or won't do when determining whether a worker is properly classified is an open question. We don't know. Most people think that they are going to go do nothing and go towards enforcing this area again for tax reasons. And given that we are signing lots of bills that are moving money from our federal government to employees and businesses, that has to come from somewhere. So I strongly expect the independent contractor test to continue to be vague, and also for this to be a focal point of the administration with regards to its enforcement actions. So it's going to be an interesting situation, because I think we had a solution potentially, and for whatever reason, the way it was put in the memo was that the rule that the Trump administration came up with was rescinded because it would make it less likely to establish a worker as an employee under the FLSA. Well, in my view, whether it's more or less likely isn't the test. The test is creating something that makes it clear for everyone what those rules are. So for me, for small businesses, this particular decision is a huge disappointment. On a personal level, it gives me lots of work for a long time because there's going to be a lot more uncertainty and a lot more challenges. And also, our world is evolving now into much more remote workplaces. People are working from home. People are starting to take, kind of gig economy jobs and do contracting for side jobs. And, technology has advanced and continues such that that becomes a more part of our economic fabric. So this problem, I think, is one that's going to continue to be paramount for small businesses as well. Okay, third poll question. Is sending employees email notices of their rights sufficient under U.S. labor law? As you know, if you have a small business, you are required to do postings so that employees know what their rights are with regards to their labor law rights. We have wage and hour postings that are required that say what minimum wage is. We have postings so they're sure what their workers' compensation benefits are. Safety in the workplace has posting requirements as well. Well, if we're starting to go into a situation where more and more people in the workplace are working remotely, can you just send those notices out via email? So Allie, let me know what the poll results are. Yes, no, it depends, but I'm not sure on what, or it depends and I can tell you why.
Okay, it looks like we've got 50-50. 50% said yes and 50% said no. So I think we need to answer some.
Good question, because at least 50% of you will benefit from it. Okay, well, we're going to talk about it because it's an interesting area to think about. People know they need to be posting things. They know there are annual posters. You probably have companies that want to charge you 50, 60 bucks to give you a poster, but all of those posters are available for free at the agency websites if you have the initiative to do that. Regardless, the idea here is that it depends. Okay, and I suspected that I'm probably the only one who could tell you why, because I keep up with this, and one of the blessings I have is the opportunity to share this with you so that you can go from A or B to D here and be able to know why as well. So if you're dealing with remote workers or hybrid workers that are going to the workplace maybe one day a week and working away 3 or 4 days a week, however you have that structured, you have notice requirements still. And guidance was provided in December regarding this because it became really clear that people were arguing, mostly plaintiffs' attorneys, that there's no way for these remote workers to know what their rights are because the postings are back at the office you no longer require us to go to. So the Department of Labor proposed some guidance with regards to the Fair Labor Standards Act and the Equal Pay Protection Act and the SCA Service Contractor Act as well, FMLA, all of these federal laws that deal with postings from a labor perspective. And ultimately, the challenge here is the way the law was written is that it requires continuous postings at all times. So if you're not going to the workplace, is that really effective? Or if people never see the workplace because they just work remotely, is that effective? So what the guidance says is that electronic postings are acceptable substitutes if they're all working remotely and you have no central office. And some businesses may be able to do that. Or if they customarily receive it via electronic means, or if they have readily available access to postings at all times, which means it's on a website. And the challenge here is that an email in and of itself, while they could or could not save it, probably won't cut it in terms of the analysis. So what I am going to do is give you some recommendations on what I think small businesses need to do to address this problem. First, I think they need to, if they don't already have one, have some sort of intranet or portal. And on that, make sure that all employees have access to it and all of the posters are there. If they are on a company intranet or portal, the important thing is that it be accessible. So consider making those things maybe automatically appear on the employee's login if they're logging onto business equipment, and telling them they can't change the main login page, so that all of that is readily available. Also, I would encourage all employers henceforth to, similar to or incorporated with their employee handbook and acknowledgement, make sure that an employee acknowledges the virtual location of those postings. It's easier for a guy like me to defend that that employee knew where those postings were if they've signed something that says so. So in your infrastructure, because you're already creating handbook policies and procedures and having acknowledgement forms, I would say incorporate an acknowledgement of the virtual location of all workplace postings that are required under the law. And then you have something to demonstrate that employee was advised of it and they acknowledge that they were advised of such. If you have hiring practices where you are dealing with applicants through a portal or an applicant tracking system, make sure that you're creating notices at that time as well. Don't ignore the application process. And there's an advisor page on the Department of Labor called First Step Poster Advisor that can help clarify how to create these things in your system. So I wanted to give you those, or a link to that. I can send you a copy of a link to that. If that's something you're interested in, please reach out to me or leave a question with your name on it and contact information, and I'll be happy to respond to that and give you that link. But if you were to just Google First Step Poster Advisor, Department of Labor, you would find it quite easily. Okay, that's all my questions regarding this posting issue. Now I want to turn to some legislation that is currently out there that I think small businesses should be aware of. The Paycheck Fairness Act has been proposed annually for a long time, since 1997, and has never become law. But under the current administration and under Congress as it's currently composed, especially in the Senate, there's a chance that this might become law. So I think it's important for businesses to be aware of what it is. The Paycheck Fairness Act, for one thing, would limit, in some ways, employers' defenses with regards to aspects that it used to utilize. We have in the law the idea that if it's a factor that's utilized that's other than what's being alleged, that might be an affirmative or other defense to the thing. For instance, if your pay differential between men and women is based on something other than sex, and you can demonstrate that, then under the law, that is frequently something that can help mitigate risk and liability. Under this new act, the ability to do that will be taken away. the only factors can be bona fide job-related factors and not other factors that may impact that. This is a little complicated for this audience because it's more of a lawyer issue about defenses that are possible. But what you need to know as an employer, the key takeaway is, hey, it's harder for you to protect yourself because defenses are being taken away under this new law. That's the key message. Another part of it is non-retaliation prohibitions are enhanced. And when I mean enhanced, damages with regards to those are enhanced. And that's actually another bullet on here as well. You can't, according to this new law, if it were to go in effect, it would be unlawful to have an employee sign some sort of contract where they are prohibited from talking about their wages. And this is a weird area of the law. Businesses discourage, some businesses have policies that are illegal with regards to talking about how much you make to coworkers. The reason I say they're illegal is because there are laws that encourage and protect employees from talking about terms and conditions of the workplace. So you have to be very careful about the idea of what employees can or cannot say with wages. Now, clearly this deals predominantly with the private sector. If you are a public sector employee, the sunshine laws make all of your wages public information. So it's not as much a public sector issue as a private sector issue, but most small businesses are private sector, so it fits our demographic here in terms of my audience. So can an employee talk about their wages? If this law passes, then it's going to clearly be unlawful to do anything proactively about it, and candidly will make it clear that transparency of wages is permitted. Whether you agree with wages should be or should not be transparent, I'll leave that to your own judgment. My purpose here isn't to weigh this, but to inform and educate you with regards to changes. And employees very well may have much more access to wages of coworkers in the future than they do currently. And that's something I think small businesses need to be aware of. This new law would also add punitive damages to violations of the Paycheck Fairness Act. So getting involved with litigation creates much more risk for businesses because the penalties under this act only go one way, and that is to give the employee or to penalize or punish the employer. And so it's an act that right now is before Congress. HR 7 is the law. The Department of Labor also has been asked to collect data on gender, ethnicity, job classifications, wages, pay disparity, and make that available to assist the public in understanding and addressing wage disparity in the workplace. So whatever your particular view is on this, I respect it. I'm not here to challenge one view or another. I'm here to inform you as to this law, because as a business, there's no doubt it would raise risk. There's no doubt that retaliation with regards to employees that share information is prohibited and penalties are enhanced. And there's no doubt the Department of Labor will start asking questions that are going to support whether or not businesses could potentially be targeted for audit and or other administrative actions because of a belief that they might be treating women differently than men in the workplace. So it's an interesting law that's on the horizon that I think under the current composition of the Congress has a strong possibility of becoming a reality, and I wanted to make you aware of it. Okay, the last aspect of it deals with employee benefits, and for our purposes, one of the biggest aspects of it is the idea of mandatory paid leave. So my last polling question with Allie, is there a mandatory paid leave in Florida? Actually, we took this off, so I'm not going to ask you this. I'm going to give you all of the answers to think about. A through G. Is there mandatory paid leave in Florida? Yes or no? If it's yes, could the legislator pass something last year? Did Congress pass something that created it? Perhaps they created a paid leave with the Coronavirus Act of 2020. These are things to think about. You may or may not be aware of, depending upon how involved you are with employee pay. No, employers were required to pay it for a period of time under that act, but no longer. And so I'll tell you that the correct answer is D and G. And the reason is that the American Rescue Plan now will extend the benefits that ended at the end of December of 2020 under the Family First Coronavirus Act. If that didn't confuse you, I don't know what will. So let's try to simplify some of it. When the virus hit in March of 2020, one of the first things Congress did was try to find a way to respond quickly. And that effort produced the Family First Coronavirus Response Act. This particular law was designed from the outset to sunset at the end of the year, and it did expire on December 31st of 2020. So most employers have already dealt with all of this, and they had to pay sick pay, but they were going to get that back as a tax credit attributable to their business taxes. So the idea was, we're fronting you the money and the government's going to pay us back. And that was the thought process. And here are the parameters in which that was laid out. But that's not really important right now. It's already happened. What is important is that the American Rescue Plan, which was signed like just recently, December 12th, provides for lots of things. And among that is that it gives credit to businesses that voluntarily offer their employees paid sick and family leave. And that credit will go through September 30th of 2021. So the benefits that you offered your employees for paid leave that were mandated under the law in an extreme emergency under the Family First Coronavirus Recovery Act are not reenacted. But if you voluntarily want to keep those types of programs through September, the government under this new plan will pay you as tax credits the money back that you put into it through that time. That's part of this recovery plan. I put other aspects of it on the screen that impact employers because I certainly wanted you to be aware of them generally. But for the purpose of my discussion today, really what I wanted you to understand was that the American Rescue Plan includes the ability to continue voluntarily paying sick leave and family leave and continuing to get credits even though that law is expired, because for that limited purpose through September 30th, the government has agreed that it will continue to pay credits back to businesses. Other aspects of it that I think are important are primarily dealing with assisting unemployment, and there's extensions and limits with regards to how much unemployment benefit and how long they'll be extended and for what purpose, and also COBRA coverage, which is very important with regards to insurance coverage for people that are in transition. And of course, what everyone focuses on is the stimulus payment of $1,400 for most Americans that will go out. So that essentially is where we are on the federal level with regards to it. Florida has no mandatory paid sick leave laws, but you might be involved with or work with businesses that are multi-state, and so you need to know that predominantly in the Northeast or in the West Coast, there are states that do have state mandated paid leave laws. And there's a quick map so you could see where they are if they apply to you, but I don't expect most of them to. So that, my friends, is what I wanted to share with you today. I hope you found it valuable. Does anyone have any questions I can help with?
Okay, well, we give our attendees a chance to enter any questions in the question box. I have a question, Mark.
Okay.
You know, I mean, we talked about independent contractors, we talk about posting posters and paycheck fairness and all that. What kind of trouble can you get into if you don't do this right? And what are the
Well,
penalties that are,
typically, and it depends because it depends on what is alleged that you did wrong and whether or not there's a track record of doing it wrong. Most of what will happen is either going to be prompted by a government audit where they notice things are inconsistent, or a employee that complains that they weren't compensated properly. And if an employee complains, then you'll get a call from a investigator who will want to get records immediately and want to visit your work site and talk to other employees. And so handling that situation, I strongly advise you to get counsel quickly and to have counsel there when the agency's folks are there. Because there are rules and things that agencies can and should not do. And there are things that you can do as an employer to set yourself up proactively to mitigate some of the risk. So getting with a professional that deals with this is valuable. As far as what the damages are, it depends on what the allegations are. I mean, and it also depends on whether or not the agency thinks that you're a systemic violator or you've looked for ways to circumvent the law, as opposed to make an honest mistake. I have been able to get agency investigators and administrators to not assert the maximum, but there are cases in which they will not come off the maximum. You know, so it just depends upon the totality of the circumstances, what we're dealing with. The biggest fear of all of what I've shared with you today for me, independent contractor status is not a change. I mean, the Biden administration had a beautiful solution, but because it was promulgated by the Trump administration, I think they gave it very little effort. In theory, they're going to revisit that and promulgate their own rule. I pray that it be simple and clear like the Trump was, but it's clearly going to be different because the Trump rule, they said, made it less likely for workers to be categorized as employees. So
okay,
wherever that is going to be a challenge, but it's been a challenge for years, so it's not new. Small employers dealing with minimum wage, I think, is the scariest part of all of what I've shared with you today. In the hospitality industry, it was a very narrow margin industry when I was involved in it. Restaurants averaged between 5 to 7 cents on the dollar going to the bottom line. And so you had to manage very close, tight controls. And the idea of labor costs doubling, which is one of your largest P&L expenses, is frightening. How you make that up structurally through increased pricing, what that does to the demand of your product. There's a lot of really, really major business decisions that need to be made in industries like that. So I worry a lot because in the Florida's economic structure, we have a lot of hospitality, we have a lot of agriculture, we have a lot of low wage industries. Florida, the state of Florida for years has led the nation in litigation on wage and hour issues. And I will tell you that I gave a presentation the other day to some students at my class, and I was talking about wage and hour issues, and I learned that at one point, 1 in 4 cases on wage and hour issues in the entire country was brought in Florida. It was actually 24%. But that's astonishing to me. So Florida has a lot of challenges with wage and hour law. And so I encourage people to make sure they understand their compliance requirements as much as possible.
okay. We do have one question. Could you please send a list of the posters we're supposed to have posted? Any other opportunities to learn about employee handbooks and basic compliance issues?
As far as I'm concerned, yes, I'll be happy to forward to Nancy. She can forward to you guys ways to find the posters. That's not a difficult thing to do. You know, many businesses will pay a third-party company $50 or so and get their posters that way. but you don't even have to do that. I mean, it's available. It's public information. You just have to go get it. With regards to learning about employee handbooks, I'll tell you that I like to educate, but in my particular practice, I'm so busy with either educating or litigating that I don't draft a lot of employee handbooks, and I usually offer those to what I feel like are very, very solid human resource professionals in the community. And so I usually will refer handbook work itself, but I do have a lot of employers that say, no, Mark, I know you, I like you, I want you to bless this. And I said, well, go have them do it because they're going to do it a lot less expensive than me. And then ask me to review it at the end, and I'll charge you a little less. You probably net less costs and still get me to look at it. But spending my rate to write a policy is probably not the most highest return on your investment. I think you can do it just as efficiently with some good HR professionals. That's why I usually refer that out. Basic compliance issues was the last part of your question. And that's part of what I'm doing right now, is talking about some of the things that are upcoming in the pandemic age. But classification and common mistakes, I actually have some online classes with regards to common wage and hour mistakes, for instance. But another aspect of compliance in the workplace that my presentation didn't really address, because it wasn't wage and hour, but is certainly high on the minds of people, is workplace safety. And workplace safety with a virus and pandemic, dealing with employee issues that are asking for time off to go get vaccinated and deal with those types of issues, are complicated. And a lot of that law is being written as we're dealing with people that are alleging violations of rights and whatnot. So it's a difficult area right now. I like doing webinars, and we'll probably do more. I'm proud that the SBRN, who I've been affiliated with for years, had allowed me the opportunity to do this one. And if there are more specific topics that you have on handbook policies and or compliance related issues that you would like me to talk about in a webinar, if you want to forward that information to Nancy Boyle, I'll be happy to work through SBRN and do more of these in the future. It would be a privilege.
Okay, and I'll also give a plug for Small Business Resource Network. If you're looking for an HR professional, you can go to sbrn.org, click on Find a Professional, and in the keyword search, you want to click on Northeast Florida, and then in the keyword search, you could put Employee Handbook, you could put HR, and it'll give you a list of the members who are employee HR consultants. All of these people have been vetted at least for a minimum level of experience, and so you can feel confident in contacting any one of them. So I want to thank everybody for attending. Mark, I want to thank you for a great presentation, a lot of good information. Shortly, you'll receive an evaluation on today's webinar and a link to the recording. So if you need to go back and review it, you are certainly welcome to do so. So thank you again for your participation, and thank you also in advance for completing the evaluation. Mark, thank you. Have a great rest of your day. Allie, I'm turning this back over to you.
Great wrap up, guys. I think that's it. So I'll go ahead and close it down. Thank you, everybody, for participating. We appreciate it.
Bye now. Thank you.
All right. Bye.
Have a good one.